please help me in welcome Mr. Frederick Greenbaum.
Hi. How many of you work in workers' compensation work like every day? I mean, and then how many of you get in it when you get calls from your clients and have to, try to deal with their emergency issues, that type of thing? Is that something that's pretty common across the board, or is that something that you deal with? I mean, trying to understand. Okay. What we've done, and probably flip the first slide, in Kansas, there have not been significant changes in the Basic Act for 17 years. And over the last few years, there's been some significant controversy. Not only what has occurred is at the highest levels of our court system in the Supreme Court in Kansas, they've decided a couple of decisions based on strict construction of the statute as it had been written before, and it has created some real urgent issues in the state. What has happened now with basically I would say, the recent elections and just the way matters are going forward, this year is the opportunity to see reform in the Kansas Workers' Compensation Act, and I'm confident that we're going to see that. Now, what happened is we went through a process where myself and 4 other attorneys on the defense side, Tony Anderson, Lindsay Spiking from my firm, Larry Carnes from here in Topeka, and Gary Terrell, worked up changes that we felt were necessary to the Act. We then went into sessions with 5 attorneys from the claimants bar, John Ostrowski and Jeff Cooper, and Jan Fisher from here in Topeka, and Dennis Horner and Tim Alvarez from Kansas City. They got input from the Kansas Trial Lawyers Association. We had negotiations that went, long into the night and virtually every weekend to ultimately get a compromise bill that we essentially completed. A bill that passed the House last week is our compromise bill with amendments that the House has added to the bill. So what I will go through today is some of the key points that are in the bill that we worked out. What I want you to do, though, is tell me when you have questions that come up, and if you have questions that arise or that you see in work comp and you're wondering how the system works generally today and whether this will impact it, feel free, back right up. Ask the questions. We'll try to make it as much give and take as possible. First, I don't know that we have a whole lot to talk about with this first slide other than I have tried to make sure that every step of the way that we maintain the exclusive remedy that falls in workers' compensation, that where if an employee has a claim against their employer, that the only place that they can get compensation is in workers' comp. I'm a little concerned with some things that were floated around that are possible that could, you don't want that exclusive remedy provision, you don't want that violated because you don't want your employers, you don't want your clients to be subject to lawsuits and the damages that come from the lawsuits. So that's part of the education process that I've had to deal with some of the different sections and trying to explain that you have to be careful as to what you take out of the Act, because if you take it out of the Act, then you're going to end up in civil court, and you could have far more significant issues. And sometimes when you're having these discussions, the thought is, well, we need to keep this out of the Act, or we need to keep this person out of the Act, we need to keep, well, you got to understand, if they're not in the Act, then they're down the street in Shawnee County District Court, or they're in federal court, and that's not really where we want to be. Okay, let's go to the next slide. There are some changes, and we're working through some things still with the drug and alcohol defense. The one, just to be very quick and brief on what we think we've done that really matters, is one, you've had this standard in Kansas where 0.08 or 0.04 you're presumed to be impaired, which is good. because if your impairment contributes to the accident, then it's a defense. What we've done is we've made it that it's a presumption that if, in fact, you're impaired, then you don't get workers' comp under the Act. So it's a real strong defense the way we've written it. Essentially, if there's any relationship that shows any contribution and you're at that .04, you're not going to get comp benefits. We've had problems because they've established some real stringent measures to try to get evidence in, and we've changed that, and that's not something that would be real exciting to you, but when you're trying to put on evidence and trace, chain of custody evidence, you don't want to not be able to make your defense because you couldn't, get all of your pieces in place. So I think we're in good shape relative to that. Don't need to go into it any more than that. Let's go to the next one. We've had, I don't know how many of you, and we're going in statutory order. This isn't in order of excitement. This is in order in terms of how it is in the Act. So, so if it starts out slow, it may continue to be slow, but this is kind of slow material, but it's significant nonetheless. What had happened previously is in the prior Act, or our current Act, you get a reduction for the percentage of disability or impairment that existed prior to your employee's date of accident. The statute doesn't say whether it's calculated in terms of dollars or percentage. And the problem is if it's calculated in terms of percentage, that may not help you. Because if you get a big work disability case, say a 60% award, and you have a 10% pre-existing impairment of function award, and you only reduce by 10% pre-existing impairment, you're going to have a 50%, they're still going to hit the $100,000 cap in most situations. What we've done is if they're working for the same employer, and they have pre-existing impairment or pre-existing award with that employer, you'll get to reduce by the current value of the dollars. So if you get a case and you have a serious injury, say the employee had a 15% injury and got $25,000 a year ago. And then now they have a new one, they've aggravated their injury, and now they're coming back and they want to hit, for the whole load. With the new cap, it'll be $130 for permanent partial disability. And you were only going to be able to reduce by the percentage. With a high enough wage person, you wouldn't get the credit. Well, now you'll get dollar for dollar credit on the current dollar amount. That's it's a technical change, but it's important because what it does is it allows you to get the dollar credit off the award so you're not paying it twice, which is what I consider to be a loophole in the prior Act. Okay? We still have the retirement offset, and I don't know if you're familiar with that, but we have in Kansas, how many of you, I know Janine would be in job, but work disability, does that term mean anything to you? Raise your hand if work disability, if you understand that completely. Okay. That'll help me kind of understand what I kind of need to go through and what we need to talk about here, and maybe help you when you talk to your employers and issues that they have, and when they ask you questions, how accidents or injuries can impact their premium or impact their situation. In Kansas, there has historically, for as long as I remember, and that's 30 years of doing this, there's what's called work disability, and in body as a whole cases, if an employee loses what had been the ability or loses wage earning capacity, if they lose something that relates to their wages, there's a standard for work disability, and that's where the bigger money cases are, if I can make it as simple as possible. Well, there's a retirement offset that allows if you have an employer that has a funded retirement system, or if they get Social Security retirement, you can subtract the money they get from a work disability. So if somebody asks you that, that's the answer to the question. But I'm going to get into more about work disability and kind of tell you the problems that have arisen with work disability, why it's created big problems for your insurers, and how we're fixing that, and I'm confident are going to get the job done on that. So let's go to the next one. Okay. Now, in work comp, what you basically have in the Act is you have three types of what you call accidents, injuries, situations. You have your basic personal injury by accident. The guy who falls off the roof, that's an accident. You know, that's actually a real one. We actually don't, sometimes we're relieved to see those because they're real accidents and we know that somebody really got hurt on the job. But another way that you can have injuries or accidents on the job are repetitive trauma. And that's from overuse or doing, you know, you have somebody who does the same thing all day long, using their hands or wrists or bending over all day long. Most of them are upper extremity cases all the time, and those cases have historically also been compensable under the Act. The third way we don't see as much anymore are occupational disease cases. You can have like pulmonary disease or some type of, you know, some type of exposure to fumes over a long period of time. Your asbestos cases could be occupational disease cases. So those are your three types of injuries under the Act. What you get is you have medical treatment for the injuries. You also have lost time benefits if you're rendered temporarily, totally, or temporarily partially disabled. And then at the end of the day, whenever you hear them talking about settlements, that's when you receive permanent partial disability, which can also be permanent impairment of function. That's the medical disability, the permanent impairment of function. Or work disability, which gets back to, again, the relationship in terms of wage loss and task performing ability loss. Okay, let's go to the next slide. So I think that kind of tells you, and that goes over what we just talked about. What we're going to do and what we've done, and I think we can go to the next one too. We've set up standards for what's required for an accident or injury on the job. Now, what I want you to do is look at, first is, an accident only arises out of the employment in a repetitive trauma case, and the employment peculiarly exposed a worker to increased risk, which the worker would not have been otherwise exposed. In other words, if a worker, you know, maybe he cuts his yard at home, but if they're doing something on the job where they're moving their hands and wrists in a way 200 times an hour, that may be a situation where they've peculiarly exposed the worker to the repetitive trauma. Now, what has to happen under the new repetitive trauma standard, and you'll also see it in the injury by accident standard, is the increased risk has to be the prevailing factor in causing the repetitive trauma. I want to kind of go down a little bit too, because I want to go to the single event accident. There has to be a causal connection between the work and the accident, and the accident, again, has to be the prevailing factor in the injury, medical condition, and resulting disability and impairment.